Okay, in this lecture, we are going to talk about section number 3 in commercial law for business students, page 77 actually. We are going to talk about sales of goods or sale of goods. Introduction. Sale of goods is defined as a contract. It's a contract actually whereby the seller transfer or agrees to transfer the property in goods to the buyer for a money consideration called the price. So transferring the goods or the property of goods from the seller to the buyer for an amount of money agreed upon. This means that in addition to the ordinary elements of a contract to excuse me to other elements, goods and money, to other elements, goods and money consideration must also be presented in a contract of sale of goods. The above definition also envisages two situations, namely, number one, a contract of sale in which the property and the goods is transferred from the seller to the buyer. And secondly, an agreement to sell. An agreement to sell, it's very important actually to have an agreement to sell in which the transfer of property takes place in future at a future time or a time in the future actually, or a fulfillment of certain conditions like the money or the delivery of the property or goods or property of goods. Excuse me. A contract for the sale of goods yet to be manufactured is an agreement to sell because the property and the goods cannot pass until they are manufactured and ascertained. So they have to have in a certain period of time to be delivered or to deliver the goods actually. Sale goods and other transactions. Sale goods and other transactions. We will see that there are sale of goods and other transactions rather than goods. Sale of goods is distinguishable from other commercial transactions but similar to them in context. Some of these transactions are: number one, or the first one, sale and exchange. Sale and exchange. The consideration required in sale must be money, whereas an exchange involves a transfer of goods for other goods. A contract of exchange simply means the giving of goods to the person is in exchange for the other person's goods barter. In other words, money, which is a prerequisite for a contract of sale, is not involved in a contract of exchange actually. When there is an exchange, the property and the goods passes. The second, sale and bailment. A bailment is a transaction under which goods are delivered by one party, the bailer, to another, the bailee. Bailer and the bailee, on certain specific terms, of course in a condition, or in the condition and the contract actually. So they have to have a contract between the two of them, seller and buyer, the bailer and the bailee, which generally provide that the bailee is to have possession of the goods and subsequently redeliver them to the bailer in accordance with his instruction. The property and the goods is not intended to and does not pass on delivery, and in fact remains with the bailer though it may sometimes be the intention of the parties that it should pass in due course, of course, in the future time, as in the case of ordinary hire purchase contract. In sale, on the other hand, there is usually an indication that the property and the goods would pass to the other party in the transaction to transfer from one another according to the contract and the conditions of the contract. In other words, in a contract of sale for bearment, there is no transfer of property and the goods from the bailer to the bailee, whereas in the case of sale, the property and the goods should be transferred from the seller to the buyer. Sale and hire purchase. Sale and hire purchase. Generally, contracts of hire purchase resemble contract of sale very closely, and indeed in practically all cases of hire purchase, the ultimate sale of the goods is the real object of the transaction. The distinction between them is very clear and extremely important at this initial stage. A contract of sale involves two parties, the buyer and the seller, whereas a hire purchase actually transaction invariably involves three parties to it, namely the seller, first of all, of the goods, who sells them to finance a company with money, of course, which in turn leaves the goods on hire purchase terms to the hirer, who may not become the buyer. So he's not really become a buyer at this point. Under hire purchase transaction, the hirer, who may not be become who may or may not become the buyer, has possession of the goods and is entitled to their use, although he is not the owner. He's not the owner at that time. Sale and gift. A gift is an immediate, voluntary, and gratuitous transfer of any property from one person to another. So it's different from the other purchases or sales. In other words, it is a transfer of property without any consideration. Without any consideration, it's a gift. It means without any money. It is not binding. Sometimes problems arise with regard to transactions in which what is regarded as free gift free gift without any money, without any compensation, is offered as a condition of entering into some other transaction.